Still on Wontumi, akobom na akosibu so or join you. Someone Atta Akyea bedu Ghana and why life. Was a master judge and why no person please Jubilee House. Also judges now handle political cases. That's on ambulance mood. And I'm only doing this always a media watch crowd. And I'm trying to see me channel. I decided to do this video because I think, say, media. Obi our follow my champion on this Wontumi try. I've certainly decided not to say certain things because I've said it way back before here. But I think that the lawyers of Wontumi may do him another great disservice if they go by the standard. Some like Atta Akyea canon. Media on tone it down. I'm not a lawyer. I'm not experienced. But sometimes we also see certain things that come to pass. And I think that me meeting and I was a bit cringing. And I think say they should tone down. Now video near about 15 minutes. It do 10 minutes one advert will be shame kakrentonti, but would say from the 9th minute bana. I was very worried with some of the things that he was saying. And especially also the first 5 minutes, trying to infer that the judges are doing what they are doing to please the Jubilee House. And we've all been in this country, we've witnessed criminal procedures across government. And I think that, yes, we all have the liberty. I mean, they are posting Hanan there. Many people disagree with the judge for saying that the Hanan should travel. I have disagreed with judgment, it's normal. But I think there are certain impairments. Because you see, discretion, I cannot. The judge has a discretion. 15 to 25 years. I'm not going to say 15. So meaning that we 17, we 16, we 20. It comes to discretion. The judge is a living being. He lives in a society. He listens to the news. So I'll play it for you. Then maybe you can also share your view in it. That's my view. I feel strongly about that's my analysis. But I feel strongly about these things. I think that there need to be a toning down somewhere. Subscribe my keyboard notification. The video be at you have a comment. Feel free. Leave that comment in the comment section. We are measure also because Goldberry construction with other episodes in assassin crata some of the documentations related to your house and Goldberry the baby sage managing idea. Ma you bring poma or addition later you travel later the shade care corporate pombo besho never be a kama diama. Let's go into it strictly. And say no kind.
This is a very sensitive matter touching on the judiciary. So if I commit a short prayer and behave myself on this elevated platform, let the words of my mouth and the meditations of my heart be acceptable unto you, O Lord, who is my rock and my savior. Samson, let me be very honest with you. There seems to be an indecent haste to prosecute what I call political cases. Because there's a justice delivery system in which the judges are not by themselves in a hurry to prosecute people, to adjudicate matters. You could go and do an audit of the adjournment mechanisms in the court. If you do a proper audit, you see that look, cases are treated in the normal course of events. And a judge could tell you that, look, I'll adjourn this case. Some people can even, some of the judges will even adjourn, 2 months, an adjournment. Okay. So now, this is a special case. They take it to a special court. And the judge will tell you that, look, you can't go to another court and then maybe do a case whilst I'm waiting. You need to come to this court. And then we proceed with the case. What is the meaning of that? It is ministering to the generality of our people. Now let's do an ambulance trial relative to political cases. But when we come to the civil cases about land matters, the same energies these judges are using in trying to, adjudicate criminal cases, are they applied to civil cases? Now, if you got a very good land case, a judge will tell you, like my previous situation, come to court at 9 o'clock, and then let's adjudicate till lunch time, and then go and have lunch and come back, and I'll close at 4. Are the judges giving, their energies to the political criminal cases, but the rest of the cases which are not so, or other criminal cases, they won't give it the attention. So there is a good grounding for the position that I think the judges are in an ambulance mood to, jail people. Let me tell you something which is frightening. Justice hasn't gotten a political term of 4 years. And when some people are saying that, let's run an ambulance of a justice delivery system, then we are saying that, oh, we are trying to placate Jubilee House because they are interested, together with their constituencies, that people should be jailed. So that they say, this is a very serious government. If you are very corrupt, we're going to deal with you. And guess what? That kind of frenzy in NDC and in Jubilee House, you will not find expression in the court of competent jurisdiction. A court of competent jurisdiction wouldn't want to care about the fact that, how many people can we jail? So they will say that we are politically consequential. No, that's not justice delivery. And this is my chief concern. So, for instance, when we said we wanted the judge to consider the constitutional matters, so I'm saying, all that you need to do is that, look, I want to make a referral to the Supreme Court, and then the Supreme Court will come out with its decision on the constitutional matters raised by a counsel for the accused persons. And then that should be the way I should go relative to the decision I've given. Guess what? The decision had been put together already. The constitutional matters and even the motion to move them did not minister to the judge at all. And the judge had the judgment written out before, we look at the issue of the motion. What is that ministering to everybody? Now look, I'm ready to, do what I want to do, and I will not be persuaded by any constitutional matter. That leaves much to be desired. So there is a serious grounding for the proposition that judges who have political cases to deal with are in an ambulance mood, and that is not the rule of law.
I ask about the substantive, the outcome.
Well, with the greatest of respect, I wouldn't want to pretend that I'm in the Court of Appeal, but I'll say a few things for your consideration. Samson, it is important to come to terms with the fact that a high court should never graduate into the Supreme Court when there are constitutional interpretation borne out by the trial. I want to stress that. And the very authorities that the judge cited condemns her own conclusion. And let me refer to the Ezanoto case that the judge applied. If you look at page 12 of the decision, the judge cited the Mekankan case, and then also cited the Aduamwa case, and then came to ex-party James the question, and there's another case. At page 55 of the Ezanoto case, this is what Justice Atuguba JSC said. Indeed, in that case, the court held that a lower court ought not readily to assume that constitutional provision is plain and unambiguous. What is the entailment of this? When you are said that a constitutional matter is before you, and to your mind it is clear that this is not a constitutional interpretation but a statutory interpretation, and where rival meanings have been placed on the constitution vis-a-vis the laws under which they were charged, as expressed in ex parte Akosa, the defense is asserting that the law sins against Article 1911 because the law is not clearly defined, the Minerals Act, as to the criminal matter vis-a-vis the penal consequences of those things, and that was sinned against the Constitution. Make a referral to the Supreme Court for the Supreme Court to interpret. The Attorney General says no, that is not the case. It is plain on the face of it. Samson, I beg to submit that rival meanings have been placed on Article 91 vis-a-vis the Minerals Act, and therefore the judge should have left the matter to the only forum that is so preserved to interpret the Constitution. And for my part, this is a ground of appeal that the judge usurped the interpretation powers of the Supreme Court, and to that extent became the Supreme Court and interpreted matters that the Supreme Court is supposed to interpret.
You seem to suggest that the High Court judge, once a lawyer or a party triggers what they feel is a question that must go to the Supreme Court, should just fold their arms and push the matter to the Supreme Court. They have no discretion in the matter. That's what you're suggesting.
At all. Far from that. You see, because were there consequential interpretations before the judge, since you give me just a minute, I'll just read some of them.
We'll get into those details.
Yes.
But why do you say that's not what you are seeking? If the judge has a discretion to exercise,
yes,
and she has exercised the discretion, that from where she sits and reading the provisions that you say are vague, for that matter, let's go to the Supreme Court for an interpretation.
Yeah.
And she takes the view that they are plain, they are not vague. She can understand them. She has no need to get the Supreme Court involved. Why do you fault her?
You see, from the jurisdictional perspective, the power to interpret the Constitution when the arrival means is not reserved for the tribe.
If you want to just look busy, read books. If you want to actually sound smart and take the lead, train your speaking skills. Or scroll and stay invisible. Tap the screen.
Because the issues before her were deeper than clear. And even at a point in time, the judge actually said the penal provision is not borne out by the law. I can show you from the decision. She said that.
I read that.
Yes, it's there. So
but
if
she tells you that the punishment, as you are talking
yes,
about, which Article 1911 says, ought also to be prescribed.
Yes.
Whilst you don't find it in, is it 99?
Yes.
99 2B.
Yes.
Within the same law.
Yes.
You find it. So
yes,
she didn't understand what you were talking about, because if you read the law in full, you find it.
It's an interpretation.
It's an application.
Because, you see, she was not applying the law as it ought. Because in the sense, when there is a criminal offense tied to a penal situation, a consequence, understand, and one in which it is not borne out by the law that this particular infraction is tied to this, what's it called, penalty, then it says against Article 1911.
We'll get into the details of that.
Yeah.
But in your own address to the court,
yes,
you told the court that if you do not agree with me to refer the matter to the Supreme Court, you said alternatively, that's the word you use.
Yeah.
That means you anticipated that the judge has the power to agree or disagree with you.
That is the way that every sensible lawyer will argue. Because there are two scenarios. Either the judge will comply with the Zanotto principles and make a referral to the Supreme Court, or the judge could say that it is plain and clear, I'm not going to refer anything. Then in the alternative, look at what I've proposed as my written address. Because something, it would be very, very, very unprofessional of me just to have addressed the court on the issues of constitutional matters and leave, excuse me to say, equally important submissions on the charges and arguments pertaining to them, unattended to. And I think that will be very, very
I'll go to Inusa. Sorry, forgive me. But a few things I need to clear with you from the very, forgive me, from the very, commencing statements that you made, confirming your earliest position that these courts, where the criminal prosecutions of the prominent cases, politically, exposed persons
Yeah.
are ongoing appear to be in an ambulance mode.
That is so.
And that the courts we normally know can give adjournments 2 months, as you say, and so on, but here they are not allowing that to happen because they are in a hurry.
Yes.
Is that not what we have always prayed for? That we do not have situations where cases are unduly delayed. In fact, Godfrey Dame, the boy Dame, was proposing a legislation where these criminal trials will be held on a daily basis.
Yes. You see, I've made an assertion I want to repeat. Justice hasn't gotten a political term of 4 years. And therefore, if justice is being run as if we want to, have a political term of 4 years, then we have a challenge. I don't believe in undue delays. And equally, I want to argue that I also don't believe that justice is being hurried. For what? An end to placate where? Jubilee House. I don't believe in it. Because, for instance, are you sure that where a judge has not heard arguments on the need to make constitutional referral, which is, excuse me to say, at the very heart of the case, and it could turn the case one way or the other, the judge said, don't move this motion because I've captured your thinking already and it's embedded in the judgment. You know what that means? I have made up my mind. Don't disturb me with the law. That's what it means. And she comes around with a prepared judgment and delivers it.
Not comes around with a prepared judgment. A judgment whose date was announced in advance.
Yes.
A month or more.
Yes.
And it is the expectation of all parties, all players, that the judge will be writing the judgment.
Yes.
So writing the judgment is not sudden.
I understand that.
Right. If you say these cases don't have a lifespan of 4 years or political life cycle, some people will disagree with you. Why? Because already we are hearing that if you are not successful on appeal and so on, and the NPP wins power, Wontumi will get a pardon to be released. We saw the Opuni line of cases.
Yeah.
That took 7 years. They didn't finish. The Attorney General came. What did he do? Released all of them. Stop all those cases.
Yes.
So Ghanaians are becoming aware that that statement you made is not true.
I'm afraid they are being political to the point that they want to subordinate the judicial process to their political pleasures and appetites. And therefore they are saying that, can you aid us and hurry justice so we jail our political opponents? Is that the rule of law? And the judges should guard against that. If the judges are in an ambulance mood because they want to appease the political, government, to achieve their political ends, then I'm afraid to say,
okay, so
the rule of law is undermined.
Yes. Now, you see, Samson asked him that, are you saying, say, what the old raise as a constitutional matter, and you invoke Article 132 as so certainly the judge should go to, and he said something that no. So it means that the judge has a discretion. And when it comes to matters of discretion, is there. And I make to watch it. There are many watches sellers from Kokomi all the way to Boedi. But I make baby back. Discretion. That is basically what discretion means. Meto na mento one is based on something be an namne nyamede. Ebi an willing no, ebi an steal no, ebi an watch no. Any discretion. That is basically what discretion means. So if you are talking about discretion, the greatest of respect, as I've said, I'm not a lawyer, but I think that discretion will come down to certain ingredients. First time offender, and the judge said it in the judgment. Nipa behavior, the commentary. Ebra, na mi swade na menyi certain I was old. 2013. Ebra ye che contempt for no. Kutie Justice Atuguba. Asamo kan. What's more than some change to kasa answer na yenti on yeti. And I've said that the court is a living organism. They live within us. The court, because the judges make the court. So I think that The law is clear. Me cancer me 15 years, the minimum sentence. I've said it publicly. You are entitled to disagreement. That's fine. Obi to so 25 years. That is the person's view. But the MPP has an opportunity and Wontumi so have an opportunity in law. It's not the tribunal make us. Me, one of the things I'm happy about, so the appellate processes. You can appeal it. You can go to the Supreme Court. You can go to the appeals court. Go to the Supreme Court. That is it. So I'm court near sign Wontumi fine. And I'm not church Ghana. But justice dispensation comes down to the law and discretion. It's in your range bano. Say the judge no on the discretion come be 100 years. Obetimi akwa kwesi 25, obetimi akwa kwesi 15. It's a discretion on be 20, 17, 18. It tells you that that person or that judge will come to the conclusion of the years to give to the person based on certain elements, and therefore commentaries around the judgment should be seen to be decorous, in my view. It shouldn't be seen as denigrating, because many trials have done this, and one thing I hate to do is to go to history and mention cases. We've been in this country where people in wheelchairs wheel to court. Was it because they had to plead the government of the day? No. You see, the reason I'm always careful about the judiciary, and come here, the documents here and say, Parliament is gone. And then here, Parliament is gone. It's become a rubber stamp. Our executive is gone. The last bastion for you and I is the judiciary. So you're not careful now. We sit on public TV and go that tangent of a year. Mama no ku for the boni. They be prove you. And unfortunately, sometimes I'm not happy doing these things, but I have to do it because obiati bibia no they run it. Yes, we no run it. I struggle to understand these things. You get it? So I beg you. Wontumi has my church mukra chairman. No, ya me catch. Wontumi ti ku fie. So wunima Wontumi betimi akofie. My church ni nyina ma kira say obetimi akwapiu. Or kwapio when because on pending the determination of that pew. A bet me akona san betian, a bet me kwa akoni akoma Wontumi 25 years. A bet me kwa akoni ama Wontumi be 15 years. A bet me ko Supreme Court make say oh sorry 14-1 59 and then 992B no a vague overbroad and the yanko sachira a lot of things can happen. It's not finito. It's not finito. I think that in as much as you may not be happy with the judgment, let's all gauge our words, because at the end of the day, the law and the discretion, and that is the law. It's not as if there's no you're throwing a new status quo. That has always been the position. Mimi view no, I don't know what to make of it. Share your view in the comments. So we are not subscriber, mommy. Subscriber, no click the notification. The video be at my what we are also be showing see the mommy. Ghana see here. Bye bye.